And we are streaming.
Please rise. Highland County Common Police Court is now in session, and Honorable Judge Rocky K. Cross presiding.
This is case number 21 CR 115, State of Ohio versus Patty A. Sullivan, appearing on behalf of State's Assistant Prosecutor King, appearing on behalf of defendant is Attorney Carl Dallas or Cordelis?
Cordalis.
Cordalis, okay.
Take her.
Right. And you are Patty A. Sullivan?
Yes.
All right, Mr. Sullivan is charged in a 5 counts act, 2 counts of theft, 3 counts of forgery. This is a plea hearing set for a pre-trial. Originally, we had pre-trial on the 1st of September, it's a final pre-trial. But I think next week, and then the pre-trial set November the 8th. So the matter was set today for plea hearing. And I have been presented with some documents here, Ms. Sullivan, that indicate that you are going to enter a plea of guilty to what's called conversion program. This is a form that's 2 pages long, and has your name and the case number on it. It's titled Plea of Guilty Prosecutor Conversion Program, and it says you're going to plead guilty to counts 1 and 2. On page 3, there's a single sentence at the top that says I entered the plea voluntarily. Below that, there's a name or signature line for the defendant, and it appears that that's Patty Sullivan. Someone can add that signature looking at it.
Yes, sir.
And when did you sign this agreement, Ms. Sullivan?
I believe it was 3 days ago, Your Honor.
Yes, that was 3 days ago.
You signed it in the presence of your attorney?
Yes.
And did you read through it with him and have him explain everything to you and answer any questions you had before you signed it?
Yes, sir.
And you understood that it's an agreement to plead guilty, which means it's not going to be trial in the matter intended.
Yes, sir.
And are you entering into that agreement voluntarily?
Yes, sir.
Now, I'm sure your attorney has explained this to you, but so I need to go over this on the record, so it's clear on the record that you do understand what you're doing. Normally, when a person pleads guilty or is found guilty after a trial, then the judge sentences that person for the offense to which they pled guilty or been convicted by a trial. And that could be probation, maybe parole, could be a prison term, could be a local jail term, could be a fine, could be any combination of those different things. And then that person then has a criminal record. And if you plead guilty to a felony and you're found guilty of a felony, then you have a felony conviction. Now there is a program which is proposed that you go into in this case. It's called a conversion program. What it is that the court has approved by an entry a number of years ago. It's a prosecutor conversion program whereby people plead guilty are not found guilty, but instead are given the opportunity to plead an agreement with the prosecutor's office regarding the matter, which is monitored by the prosecutor's office through the probation department. And if the person successfully completes the conversion agreement, then the charge is dismissed, or charges, even though there was a guilty plea. Because if you enter a guilty plea, until the court finds you guilty and sentences you, you're not guilty and you're not convicted. And so even though the file will reflect that the guilty plea has been entered, the case will be put on what's called a stay or an active status, and it will be taken off the books as an active case and still be there, and it will show that you pled guilty, but it will show that it's improved. And so if you're asked to get a felony conviction, you can say no, because I pled guilty, but I haven't been found guilty and I haven't been sentenced. Until you're sentenced, you're not convicted. And so this gives you that opportunity to go through that. There are some supervision conditions that the prosecutor's office has, or that have been approved by the court that are in the agreement, and then the probation department has appropriately monitored the person for that. Those conditions are much less restrictive than if a person was convicted of regular community control or probation. Now, the advantage to you is this. If you successfully complete the program, then the charges are dismissed. And even though you plead guilty, you're never get convicted. And it's the policy of this court, anytime a person successfully completes the conversion program, that I automatically set it for hearing the seal. And unless there is something usually that happens between the time that's dismissed and the time of the sealing record, which is about 30 days, and the records are sealed. And the only way that usually would stop it is if it came up that got in trouble again or something, or there was something that came up that nobody knew about, then the court had to take a look at it. But at this point, I can tell you that I've not, the last 4 or 5 years, I don't think I've had any where I haven't seen it. There's never been a problem. And so that's the advantage to you. And then once that happens, then the records are removed from the public record, and all the law enforcement agencies have copies of have information about them, have to seal those records, remove them from access by users of the system. Now, the disadvantage to you is this. If you don't complete the program successfully, then the prosecutor pretty much has a legal determination that it has to be done in good faith, but it's their decision as to whether or not you comply. And if they notify the court that you haven't complied, then we send a hearing to come back, you have your return it, and at that point you're found guilty, and then the court does impose a sentence. And so that's the way that works. And then you do have a felony record. Do you understand that?
Yes, sir.
Okay. Now, the agreement states that you're going to plead guilty to counts 1 and 2, both of them being theft under Plan 13.02A1. Further states on page 1 that you understand that the maximum prison term for those offenses is 12 months in each. If the prison term were to be imposed, it would be as little as 6 months up to 12 months. There's also a fine available of $2,500. And if you're convicted of both of those offenses in the future and sentenced to prison, then those could be served consecutively, meaning it could be 24 months as a maximum, and a maximum fine of $5,000. You understand that?
Yes, sir.
You're not facing any felony charges anywhere else, are you?
No, sir.
And you're not on community control, probation control, community control, post-release control for a felony.
No, sir.
Now, I have to give you the worst case scenario. That's the reason I'm going through this. So, if you were ever found guilty of these charges, and if you were sentenced to prison for these charges, once you completed the prison term that was imposed by the court, the law provides that adult parole board can, at their option, decide you should be supervised after you get out of prison for a period of up to 2 years of the term they set by a parole officer. And so the court has no involvement with that. And if they decide that that should be done, then you will be supervised under the conditions they set, and if they determine that during the period that you're under supervision, which could be anywhere from 0 to 2 years at their discretion, then they can return you to prison to serve an additional period for violating those conditions of up to 9 months for one violation. But there is a cap of half of whatever prison term is ordered by the court for all violations. But if you committed a felony while under post-release control supervision, then in addition to whatever sentence the judge in the case imposed by that judge could also sentence you for committing that offense while under post-release control, in this case, to an additional period of 1 year, whatever time's left on that 2 years or less of post-release control, whichever is greater. If that occurred, that would have to be served consecutively the sentence in the new case. You understand that?
Yes, sir.
All right, now, even if you fail to apply the conversion program and come back to court and are found guilty, I don't have to sentence you, or the judge, or whoever the judge might be, or me, does not have to sentence you to prison. You can still get what's called community control or probation. What that means is that the court will put you under supervision of the probation department for a period of up to 5 years under the term set by the court. And if during that period of time that you would be supervised probation without you were compliant, then at that time they would notify the court in writing and insert a copy upon you, and then you would be entitled to have a hearing and be represented by an attorney. And if the outcome of that hearing was that you had failed to comply, then at that time the court could revoke your legal control and then sentence you to the 24 months and fine you $5,000. You understand that?
Yes, sir.
Right now, count one alleges that on or about May 1st, 2020 in this county, you did with purpose to deprive the owners Christopher and Brittany Hutchins of their property, knowingly obtain or exert control over said property, to wit, $2,017 U.S. currency and other miscellaneous items without the consent of Christopher and Brittany Hutchins, the other persons authorized to give consent, and the value of the property being greater than $1,000 or less than $7,500. A violation of section 2913.02A1. So that's the charge of that. Fifth felony. Count two alleges that on or about March 10, 2021, in Highland County, Ohio, you did with purpose of deprive the owners of checks of their property, only obtain reserve control over said property, to wit, $2,017 U.S. currency and other miscellaneous items without consent or check mark. Smart, the owner's persons authorized to give consent, value of the property being greater than $1,000 less than $7,500. So that is also a violation of section 2913.2A1. So those are the charges that proposers should plead guilty to. Right now, Ms. Sullivan, do you understand what it is you've been charged with, what the state says you did in each of those charges, and when, where, and how they alleged you did?
Yes, sir.
Have you discussed those charges, the evidence of the case, the possible legal issues of the case, the possible offenses you try to raise in trial, and the possible outcomes of the trial with your attorney?
Yes, sir.
And are you satisfied with his advice and competence in this matter?
Yes, sir.
Now, are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Do you take any prescription drugs?
No, sir.
All right. Have any threats been made to make you plead guilty here today?
Sorry?
Have any threats been made to make you plead guilty today?
No, sir.
Okay, now on page 2, there's a portion that's underlined. There's 4 lines that are underlined about halfway down the page, so I'll read those into the record here. Defendant shall enter plead guilty to count 1 and 2. Count 2, state will dismiss the remaining counts. Prosecuting attorney recommends the defendant be placed in the Miami County Prosecuting Attorney's diversion program. Defendant agrees to make restitution in the amount of $4,034 to checks. That's the end of the quote. Now, does anyone want you anything other than that to get you to plead guilty for today?
No, sir.
And I don't normally say this in plea agreements, but typically if there's diversion, the court will put the person in. If I want to do it, I tell you. But under the law, the recommendation isn't by that. Or I could go ahead and find you guilty and sentence you to prison, but I'll have to right now. You understand?
Yes, sir.
Okay. Now, Ms. Sullivan, do you hold any kind of a license or certification from any state board or agency for a profession or occupation?
I'm a notary. I don't know.
Okay, you are a notary? All right. Well, under the law, then the clerk will have to send, if you are convicted, not if you plead guilty, if you're convicted, then the clerk will have to send a notice of that to the Secretary of State and now administer the notary commissions, and it could result in revocation of that. You understand that?
Yes, sir.
Now, you have certain constitutional rights you must understand before I can accept your plea. Now, you do have a right to have counsel before employ Mr. Cornelius. Now, under law, if you weren't able to pay your attorney, then the court would provide you an attorney. So the reason I notify you of that is just to make sure you're not entering into an agreement to plead guilty because you feel that you don't have enough money to pay for Mr. Cornelius' service. That's not an issue for you, is it?
No, it is not.
Now, under the law, Ms. Sullivan, you have a right to have a jury trial in both of these cases under charges. What that means is that a jury of 12 people would be selected from a group of citizens that are from this county, live in this county, who are summoned for jury duty under your trial. After those jurors are selected, the evidence will be presented, they'd be instructed on the law by the judge, and then they would decide by unanimous verdict, meaning 12 have to agree, whether or not the state proves your guilt on either or both charges. Now, if you didn't want to have a jury trial, but you did not want to plead guilty, you can waive in writing, which means to give up the right to have a jury trial, and then in that case, you would have what's called a court or bench trial, meaning the judge would be the one to prepare the evidence instead of the jury. The judge would apply the law, and the judge would decide whether or not the state proved your guilt or proved beyond reasonable doubt. You understand that?
Yes, sir.
Right now in the Constitution, you have a right to confront the witnesses against you and to cross-examine them through your attorney. What that means is that the witnesses against you have to come in court, testify in front of you, your attorney, and anyone else is present. After the prosecutor is done asking those witnesses questions, your attorney has the right to ask questions. That's called cross-examination. The purpose of which is to try to bring out evidence that would help your side of the case. You understand that?
Yes, sir.
And under the Constitution, Ms. Sullivan, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't. You decide. And if you decide you're not going to testify, the fact that you did not testify cannot be used against you in any way by any person at any time in the proceedings. And in fact, no one's even allowed to talk about it or mention it except in one situation, which is if there's a jury trial and you don't testify, the judge instructs the jury that because that is your constitutional right, they cannot consider it for any purpose. You understand that?
Yes, sir.
Right, and Ms. Sullivan, under the Constitution, you are presumed innocent of these charges until proved guilty by the state of Ohio in every essential element of each offense by proof beyond reasonable doubt. What that means is that the burden of proof is not on you trying to prove you're not guilty simply because you've been charged. In fact, under the law, you're not even required to present any evidence in your own defense at trial. You can, but you're not required to. But whether you present any evidence in your defense or not, the burden of proof remains upon the state of Ohio to prove your guilt by proof beyond reasonable doubt on every essential element of each offense. And that burden is the highest burden of proof that's known under the law. You understand that?
Yes, sir.
All right. Now, originally, you entered a plea of not guilty to the charges in the indictment. A plea of not guilty denies allegations, denies that they constitute crime or that you committed any crime. And that plea exercises or revokes all of the rights that I've just described for you. Now, if you change your plea from not guilty to guilty, that is the opposite of the not guilty plea. The guilty plea admits the allegations in the first two counts of the indictment, admits that they're a crime and that you committed that crime. That plea gives up all the rights I've just explained for you, except your right to have counsel. You always have a right to have an attorney no matter what your plea. But with that exception, your plea of guilty would waive to give up the right to a jury or a court trial. It would waive to give up the right to confront witnesses and cross-examine through your attorney in open court. It would waive to give up your right to use the power of the court to compel or force witnesses to come into court to testify for you, just like the state. It would waive to give up your privilege against self-incrimination because if you say you're guilty, the state that that's what's used to find you guilty. And it gives up your presumption of innocence and your right to require the state to prove your guilt, prove beyond reasonable doubt, because if you say you're guilty, then they don't have to prove your guilt. It also gives up your right to file an appeal that you think you may have had up until this point in the case. Now, if something happens in the future, or if I should in the future sentence you to 90% on either of those charges, you could file an appeal that will have you filed for 30 days of your sentencing if you file. And then finally, it does also subject you to being sentenced immediately by the court if I would find you guilty instead of pleading guilty. Do you understand about all of that?
Yes, sir.
And are you a U.S. citizen?
Yes, sir.
Now, before we go any further, you did consult with the victim, and they have agreed with this disposition?
Yes, sir.
Okay, all right. Now, as I explained earlier, the diversion program has been approved by the court, but it is something that is a privilege, not a right, as I explained in your agreement here, and that you're not entitled to hearing if the prosecutor determines you fail to comply. You would be notified, you'd be brought back to court, and then the court will find you guilty, unless there was some allegation that the prosecutor's office had acted improperly under the Constitution in making a decision. which is fairly hard to prove. And so then at that time, the court would accept your plea, find you guilty, and then would impose a sentence. And at that point, in a pleasure, you would have a felony conviction. Now, do you understand all that?
Yes, sir.
Okay. And I see you all have also signed a waiver of time and waive the speedy trial time for while you're in conversion.
Yes, sir.
Now, I should have asked this a little earlier, but you have signed an agreement with the prosecutor's office and writing you have a copy.
Yes, sir.
And so you understand what it is you're required to do to plead the program. Because I don't have a copy of it, I don't get a copy of it, I don't need a copy.
Yes, sir.
But I just make sure you're aware that there's no question about what you're supposed to do.
No questions.
Okay. I assume the component of that is restitution, and you are you going to be in a situation where you would be able to do that within the time allotted in the agreement?
Yes, sir.
Okay. All right. Do you have any questions then, Ms. Sullivan, about the diversion program, or what would be required, or what the consequences are if you're determined by the prosecutor's office not to comply?
No, sir.
You understand?
Yes, sir.
Any questions about the plea agreement?
No, sir.
You understand?
Yes, sir.
Any questions about the charges and the possible penalty?
No, sir.
You understand those?
Yes, sir.
Do you have any questions about the constitutional rights of each claim?
No, sir.
You understand those?
Yes, sir.
Any questions about the plea ability, what it means, what will happen in that plea agreement?
No, sir.
You understand?
Yes, sir.
Is there anything you'd like to speak with your attorney about before we go any further?
No, sir.
Do you have any questions about anything that I've explained here this morning?
No, sir.
It's your decision, Ms. Sullivan, to withdraw your not guilty plea, plead guilty to counts 1 and 2 of the indictment, pursuant to the terms of the diversion agreement that we've just gone over.
Yes, sir.
Okay? And as to count 1, which alleges that on or about May 1, 2020, in Highland County, Ohio, you did the purpose to deprive the owners, Christopher and Brittany Hudgens, of their property, knowingly obtained their control over said property, with $2,017 U.S. currency and other miscellaneous items without consent of Christopher and Brittany Hudgens. The owners or persons authorized to give consent and the value of the property being greater than $1,000, less than $7,500, violation section 2913.02A1 of the Ohio Revised Code, charged with theft and 5th degree felony, carrying possible prison term between 6 to 12 months, fine of $2,500 having
Guilty.
and as to count 2, which alleges that on about March 10, 2021, in Highland County, Ohio, you did with the purpose to deprive the owners Checksmart of their property, knowingly obtain or exert control over said property to $2,017 U.S. currency and other miscellaneous items. Without consent of Checksmart, the owner or persons authorized to give consent, and the value of the property being greater than $1,000, less than $7,500, violation of section 2913.02A1 of the Ohio Revised Code, also charged with theft, a 5th degree felony, and possible prison term 26 to 12 months, fine $9,500. How do you plead?
Guilty.
Thank you, proceed. All right, court finds on this date, open court, defendant was advised of all of her constitutional rights, made a knowing, intelligent, and voluntary waiver of those rights pursuant to Rule 11. The plea is accepted and ordered filed. The court finds that under Ohio Revised Code section 2935.36, there's nothing that renders this defendant ineligible to participate in the Highland County program. Prosecuting attorney conversion program has been approved by the court, therefore grants the defendant's request for admission into that program. Pursuant to the written standards of the program that have been filed with the court, the court holds the defendant's guilty plea in advance and will stay in further proceedings pending the report from the prosecutor's office regarding defendant's progress in the program. The court further orders the defendants to pay the court costs in accordance with the terms of the agreement, and also finds that she has paid the participation fee.
Yes, sir.
Has paid the participation fee, and it's also ordained the program fees that might be necessary to be done under the terms of the agreement as rendered by the probation department. And the court finds then that the arresting officer is quick to have the product of this disposition. Counts 3 to 5 are dismissed. All right, now, Ms. Sullivan, as soon as you get down here in court, please, you go down to the probation department and report to them, and tell them that you, entered, plea guilty to these charges and are in conversion program. And then they'll, put you, in touch with the conversion officer, might be Miss Archie or Miss Kelly. I don't know, there's no restructuring there, but, you're no longer under pretrial supervision condition, so, you're released from your bond. And so, you don't have to be, you're no longer under, house arrest and all those other conditions are now going to be under the new conditions, which the probation officer, will go over with you and have you sign. So, as soon as we get down here today, this morning, go right down there and, they'll have time to see if they'll have to make an appointment. Usually, or did you already have a appointment scheduled?
Yeah, I've already talked to him.
Okay, I mean, have you got an appointment scheduled like today or next week?
Yeah, I'm
Okay,
scheduled to
so-
go over
okay, so
right
you're
after I
already
leave here.
All right. Anything further, council? All right, thank you.
Please rise.